Welcome to the Supreme Court of the United Kingdom, where today we're beginning the second day of our hearing of the appeal in the case of Test Claimants in the Franked Investment Income Group litigation and HMRC. We're currently coming to the end of the submissions on behalf of HMRC in their appeal. I'll turn now to their counsel, Mr. David Ewart, please, counsel.
We have completed our submissions, my lord. We finished yesterday.
Oh, very well. In that case, we'll turn now to Mr. Aronson on behalf of the taxpayer.
Good morning, my lords. I will be dealing this morning with issue 3 from the Court of Appeal, first hearing, UFTs, E-U-F-T-S. I will then move on to the shareholder credits issue, which my learned friend dealt with yesterday, issues 17 and 18 from the second Court of Appeal. And this afternoon, early afternoon, I'll be dealing relatively briefly with the parent treaty credits, which is issue 15 from the second Court of Appeal hearing. I expect to be handing over to my learned friend, Mr. Jonathan Bremner, at something like 3 o'clock. He'll then deal with the rest of the issues, and I think we then go on to sometime tomorrow afternoon, early afternoon, if I remember rightly, before we hand back to HMRC. I think that's the timetable. UFT. This has a cameo role in this case. It only applies to dividends received after the 31st of March 2001. So we don't have to worry about semper interest or anything like that, or even compound interest. It only applies to corporation tax. It doesn't involve ACT at all. And it only applies to dividends received from companies outside the European Union. So it's a very narrow point, but nonetheless important. What do the letters stand for? Eligible, unrelieved, foreign tax. New rules introduced, as I say, with effect upon dividends received after 31st of March 2001. Eligible, unrelieved foreign tax. It sounds sort of positive, like a good thing. Eligible for something. Not quite dig for victory or take back control, not quite that snappy thing, but nonetheless something that is inspiring. You are eligible. A better acronym would have been EUFT, increased unrelieved foreign tax, because these rules had the purpose and the effect of increasing the amount of foreign tax which could not be taken into account and set off against corporation tax chargeable on the dividends. That was its whole purpose and its effect. The effect was intended to be and was severe. Had BAT, the test claimants for this issue, not spent £50 million reorganising their group structure, it would have cost them £60 million a year in extra tax. £60 million of unrelieved foreign tax, extra unrelieved foreign tax. The new rules operated up. You will have read this when you looked at the Court of Appeal, but it's not the most exciting topic, and I wouldn't therefore be entirely surprised if you haven't absorbed every detail of it. But the new rules operated by preventing groups doing what they had been doing since 1965, which was merging overseas dividends through mixer companies, usually in the Netherlands, which didn't charge tax on the mixer company. And if you merge the dividends right, then you could get a foreign tax credit, which was roughly up to the UK corporation tax rate, not entirely, but roughly up to it. So that was what groups had been doing for 35 years. And the UK tax rules were really designed to encourage this, because we're not going to need to look at it, and it's not in dispute. If you look at the way treaty credit relief was granted, credit for foreign tax under double tax treaties, forget about European, just look at the way they were granted by the treaties. Not only did you get relief for the tax paid by the company declaring the dividend, but tax paid by companies further down a corporate route. So it could be sub-subsidiaries further down, right way down. It was designed to allow things to be, dividends to be passed up in that way. The UFT rules stopped that. They introduced new procedures, no merging of dividends overseas. The only merging there could be would be in the United Kingdom once they've been received here. And even those rules excluded dividends from the lowest tax jurisdictions, the very jurisdictions that gave rise to all the problems which led to going to the ECJ on 3 occasions. It excluded dividends paid in order to comply with the controlled foreign company rules, which were ex hypothesi rules designed to encourage companies which were located in low tax havens or low tax jurisdictions, not havens, to declare dividends up to the UK. So there's no question. These rules were designed to increase the amount of tax. They changed the procedures. They took a new approach. And the last thing they were doing was to relieve any tax deficiencies or discrimination. That was the very opposite. Now, what does this part of the case deal with? It deals with the Case 5 corporation tax after the 31st of January, 31st of March 2001. The ECJ had already held that our corporation tax regime was not in compliance with Article 63 of the Treaty for the Functioning of the European Union, TFEU, the freedom of movement of capital. That's already been held, there's no question about it. And therefore, that breach of Article 63 applied to all dividends received from the EU. It would also apply to dividends received from outside the EU, provided the standstill, in inverted commas, provision in Article 64 didn't apply. Article 64 prevents a country from being held responsible for being in breach of Article 63 in respect of movement of capital involving third countries, provided that the restriction was in place on the 31st of December 1993. If it's the same restriction in place, 1993, which is when third country movements were brought in to the freedom of movement of capital, provided the same restrictions were in place, then there is no operative breach after that date if the same rules are in force. Now, the whole argument in this case on youth is whether the rules that were brought in as from 31st March 2001 were the same restriction as the rules which were in force on the 31st of December 1993? Now, the answer is obvious that they weren't. I mean, it is plain as a pikestaff. The ECJ has laid down the test as to what restrictions are the same for that purpose, and I'll run through that test briefly. There are 4 elements to that test, and the youth rules fail all 4. So there really is no question that the youth rules introduced a new restriction. And so the puzzling question here, which is the thing I spent most time really preparing, is why did Mr. Justice Henderson, the most careful and thoughtful judge, come to a different conclusion? And why did the First Court of Appeal, led by Lady Arden with her renowned intellectual rigour, come to the wrong conclusion? And there is an explanation, and I will take you through it, and you can see where they went wrong and why they went wrong. And that really is down, in a way, to timing, to the way in which the cases had been argued, the ECJ, at the time they made their decision on you. There was also an error made by Mr. Justice Henderson, which was followed in the Court of Appeal. I'm giving you an overview. I will make these propositions. But the error was, I don't know if you read his passage, but I think it was repeated in the Court of Appeal. You shouldn't look at the fine print. Stand back and look at it in the round. That's what he was saying. Look at it in the round. The rules are really the same. That was an error, because the one thing you mustn't do is stand back and not look at the fine details. You mustn't do that. And that is perfectly plain from the jurisprudence of the CJE. Let me explain why. I've said there were 4 tests. The 4 tests were these. The first test is, are the new rules in substance identical to the rules which were in force on the 31st of December 1993? In inverted commas, in substance identical. Now, with great respect, you can't judge whether something is in substance identical by standing back and not looking at the detail. Identical means identical. Doesn't mean sort of the same thing. It isn't, it's identical. The second test is whether the new rules, if not identical, were designed to alleviate the restriction. But it's as plain as a pikestaff that these rules didn't alleviate any restriction, they increased the restriction. The third test is, even if the rules are identical, did they operate by taking a new approach? And that's a sort of a generalized expression, but that's what the ECJ has said 3 times. And here, ex hypothesi, the youth rules took a new approach. And the fourth test is, even if the rules were identical, did they involve, in substance identical, one might say the effect is identical, did they involve different procedures? And here they did involve different procedures. So as I say, there really is, it's a no-brainer. Out of the 30 or 40 issues that have arisen in this extraordinary litigation, this is the no-brainer. So why did courts below get it wrong? And the answer to that, as I say, is really twofold. The first fold, you can have a first fold, the first fold is that when they heard this case, Mr. Justice Henderson heard it as a very strange moment in the development of the FII litigation. I asked yesterday the registrar if they would be good enough to send to you chronology of cases to be printed out. I don't know if you received it.
Yes, we have received that. Thank you very much.
Well, the reason I did this because it will make it easier. If you look at them now, it will make it easier to see how this evolves. And at the same time, since we're having a chronology, I also introduced the bits of the litigation here and overseas, which is relevant to the shareholder credits as well. But if you look at the chronology here, see it's in 4 columns. The first 2 are the FII cases, where you've got the domestic cases, and the second column is the CJEU cases. And then there are other domestic cases, and the famous or infamous Pirelli and ITC, and the other domestic, and then you've got other CJEU, which we'll come to. But for the purpose of this discussion, you just have to look at the timing of the FII domestic and the FII CJEU. Because this UFT issue arises from the appeals of High Court 1 and High Court and Court of Appeal 1. And as you'll see, High Court 1, 27th November 2008, came after the decision of the CJEU in December 2006. And in that case, the CJEU had held that it wasn't in breach of the treaty freedoms to operate an exemption system and an imputation system. That wasn't in breach, provided that the prejudice this caused, I'm paraphrasing, only occurred in certain exceptional cases. You may remember that. I'll take you to the passages. And the issue seemed to turn on footnote 47 in the United Kingdom's written observations, a most bizarre point. It seemed to have confused the Court of Justice. So they said there wasn't any breach. If the prejudice suffered by those who were subject to the imputation system for overseas dividends, there wasn't any prejudice, provided that was only in exceptional cases. What happened in High Court 1 is that Mr. Justice Henderson heard evidence, which was plain, absolutely obvious, that this prejudice didn't occur only in exceptional cases, but in the majority of cases. In most cases, the overseas credit was reduced by overseas tax reliefs, which didn't feed through. The conclusion which Mr. Justice Henderson reached was that had the CJEU known, they would have held that the imputation system was precluded. There needed to be an exemption system. And he says that. And indeed, that was the conclusion reached by Advocates General as well. So that was his approach. And he says in terms that had the CJEU known that this prejudice would only have been this prejudice would have occurred in the majority of cases, they would have held that the UK should have introduced an exemption system for foreign dividends. And it's because of that, and one other thing which I will come to, but because of that, Sir Justice Henderson said, well, then the prejudice, the restriction was not having an exemption system. It's the timing. Now, we know from what happened in CJEU 2, when the finding of fact by Mr. Justice Henderson on the prevalence of this prejudice, when it went back to the CJEU, they said, oh, okay, the credit system is precluded because it doesn't allow enough credit. It has to allow more credit, the famous foreign nominal rate credit. Got to allow more. That was the prejudice. That was the restriction. That's why Mr. Justice Henderson, if you like, looking at it in the round, said, well, there's been no real change. You haven't had the exemption system before. You haven't got the exemption system now. So that's enough standing back. The other point where he went wrong, I'm not saying he went wrong on that first point, it's completely understandable. Where he actually went wrong is he was, blindsided, or whatever the expression is, by a case known under the snappy name of A, Certificate v. A. You look down this list on the right-hand side, you'll see A is at 2007. It's a Swedish case, and the Swedes are not very imaginative with their anonymization of cases. So this is local tax authority certificate against A. And the revenue placed a great deal of reliance on that case and argued that youth case really on the basis of A. And with great respect to Mr. Justice Henderson, he missed the main point. And I say with great respect and with sympathy because I didn't put the main point to him. Because frankly, there were so many other issues in this case that I didn't present the case then as I am doing it now. And let me put this in context. There have been 3 cases in the ECJ dealing with the meaning of the standstill provision. 3 cases. They're all down the right-hand side. Sorry, 2 are down the right-hand side, 1's on the left. The first is a case called Conley, which is an Austrian case. The next is FII itself, the first CJEU, and the third is A. They each set out the identical criteria, or the criteria in identical terms. In substance, the rules have to be identical. The rules, if they're not identical, it's okay, the restriction stays in place. If the change is to alleviate the restriction. Even if it alleviates the restriction or the rules are identical in substance, if the procedures or the approach are different, then the restriction is not the same restriction. They all say exactly the same thing, word for word. But they deal with 3 different situations. And this is where Mr. Justice Henderson and the Court of Appeal went wrong by saying you don't look at the fine print. The first situation was a case called Conley. Conley was an Austrian case dealing with the right of individuals to buy second homes or to buy property in the Tyrol, as it happened to be. And you had to demonstrate, I've lost Mr. Justice Briggs's head. Great for my lord. So rather like I think we have in Wales now, there was a political desire not to allow people to buy property for second homes because of the socio-economic effect of people just turning up on holiday times. And there were rules introduced in 1993 in Austria, which required authorization for non-Austrian citizens and a declaration for Austrian citizens that they weren't going to use the property for a second home. and Mr. Connolly was Joe. Those rules were introduced in 1993 for the 31st of December. 1996, they changed. There'd been a bit of an uproar about it, and indeed the first rules were declared unconstitutional. And in 1996, the rules were changed, and everyone could deal with it by way of declaration. Maybe it's the other way around. Everyone could deal with it by way of authorization, but there was a sort of a fast track for Austrian citizens. So the procedure changed. So in the case of Connolly, what the ECJ looked at, the CJU looked at, were rules which applied both to Austrian citizens and non-Austrian citizens. And each set of rules changed. So if you have a comparator, the domestic case and the non-domestic case, both the domestic case rules and the non-domestic case rules changed. And they held that although the change was actually made it slightly easier, it introduced new procedures and new processes, new procedures and a new approach. And therefore the standstill was not. That was Connolly. So it was looking both at the domestic case and at the non-domestic. The next case was our case, FII, dealing with the FID rules, the foreign income dividend. And here, the Court of Justice was just looking at the overseas case, the foreign income, and saw that the FID rules introduced, even though they were designed to alleviate the previously very restrictive rules, they did it in a way that introduced entirely new processes, whole new concept, and therefore the FID rules were not protected so far as dividends came from third countries. They were not protected either by the standstill. So in Connolly, the court looked at both the domestic rules and the non-domestic rules and found that they had both changed. In FII, they looked at just the non-domestic rules. There was nothing changed for the UK, wholly UK internal dividends system. That regime remains completely unchanged. And in FII, the CJU held that the change for the foreign dividends involving a new approach, new procedures, meant that the standstill did not apply. And then in A, what happened in A only affected the wholly domestic system. There was no change in the rules which applied to dividends coming from overseas. Only change was for the rules applying to internal Swedish dividends. Let me tell you what A was about. It dealt with a particular category of dividend, bonus or rights issues from subsidiaries. And these were exempt for wholly domestic dividends, but they were always chargeable where the dividend was declared from an overseas subsidiary. Simple as that, always chargeable. What happened was that for a 1 or 1.5 year period, they were also made chargeable for wholly domestic dividends. The domestic dividends had been free of charge, they were exempt, but then they were chargeable. And then they were exempt again. But for foreign dividends, nothing changed. And it was this case, Mr. Justice Henderson and the Court of Appeal regarded as dictating that you don't look at the fine print. Now, in a way, the reason you don't look at the fine print is there wasn't any fine. There just wasn't any. The rules never changed. The restriction on the overseas dividend never changed. Nothing changed. It was exactly the same. The only change was a hiccup for a year and a half, so far as domestic dividends were concerned. That's all there is to it. But on the basis of that case, Mr. Justice Henderson said, you don't look at the fine print, you stand back. Now, that's just wrong, with great respect. You do look at the fine print. There wasn't any fine print in that case. The rules applying to the dividend from as it turned out to be a Swiss company, were exactly the same on the 31st December 1993 as they were when the case was brought. Nothing changed whatsoever. So the standstill applied. Now that was really an overview. I better make good these propositions, but I will do so by taking you to the various passages, etc. But this really, as I say, it really is a no-brainer. And what I've tried to do is to find out why the Court of Appeal and the High Court came to a different conclusion, because with unfeigned respect, the judgments of Mr. Justice Henderson are just phenomenal in this case, absolutely phenomenal. But we're just, why did he go wrong on this particular? And that was the explanation. Now, to make good these propositions, can we look at Mr. Justice Henderson's judgment very briefly? For those with paper volumes, it's Appendix 1A at tab 13, and it's EF page 1035. And it's paragraph 106, and I'll just read the first bit of it. It's paragraph 106 on EF page 1035. The youth rules are complex in detail, but the broad principles can be stated quite briefly. The advantages of offshore mixing were largely nullified by the introduction of a mixer cap, which operated to restrict the amount of underlying foreign tax which could be credited against the UK corporation tax liability on foreign dividends. I mean, if I were an American advocate, I'd say, my lord, I press my case. I mean, that's it. There we are. We have a finding of fact that it was designed to restrict the amount of underlying foreign tax which could be credited. And then if you turn the page to paragraph 107, first sentence says it all. Within the BAT group, it was estimated that if nothing was done, the effect of the youth rules would be to increase the group's UK tax liability by at least £60 million per year. And then paragraph 108. Against this background, can it be said that the introduction of the youth regime changed the legislative approach upon which Case 5 charge was based and established new procedures? Compare Connolly and the judgment of the ECJ in the present case. The youth system certainly established new procedures for the relief of foreign tax. But I do not consider that it changed the general approach upon which the Case 5 charge was based. Well, absolutely right. And let me say what, with great respect. Looking at the wrong bit. It introduced new procedures, it was. And then if you drop down, there aren't letters nowadays, drop down about 10 lines, in the middle of the page, it's a sentence that says, if one stands back from the small print and the detail, the overall nature of the Case 5 charge was, in my judgment, still in substance. The overall nature was, in my judgment, still in substance the same after the introduction of youth as it had been before. It's true that the changes would have cost the VAT group a substantial amount in extra tax if Project Frankenstein had not been undertaken to mitigate the position. And then at the bottom of that page, the sentence says, the test is essentially a structural one, and in my view, the focus should be on the main features of the structure rather than the fine points of the detail. Well, he's wrong. Sorry. It's the opposite. That's where he went wrong. The Court of Appeal, see where they were. I'll come to the Court of Appeal later. Let me take you now to the actual provisions and the three cases I've referred to, and then we'll see what the Court of Appeal says on this. The Article 64 itself, just worth seeing, is in A1, Authorities 1, tab 7 at EF 3235. If you want to just remind yourselves that Article 63 on the previous page, 3234, within the framework of the provisions set out in this chapter, all restrictions on the movement of capital between member states and between member states and third countries shall be prohibited. And then the standstill provision in Article 64, the provisions of Article 63 shall be without prejudice to the application to third countries of any restrictions which exist on 31st December 1993 under national or union law adopted in respect to the movement of capital to or from third countries involving direct investment. So it's without prejudice to the application to third countries of any restrictions which exist on 31st December 1993. So it's those words, any restrictions which exist. And then you have the three cases that deal with this, as I say, Connolly, FII, and A. Connolly is in Authorities 2. It's at tab 17 and EFP 3690. If we go to Advocate General La Pergola at EFP 3695, he sets out the two sets of rules that were introduced to deal with the acquisition of property and the protection against having property bought as second homes. It's at paragraph 3 on EF 3695, the TGVG, the acronym for the relevant Austrian law, under paragraphs 9, etc. Person acquiring the property at issue in the main proceedings is required to obtain prior authorization from the competent authority. Authorization may be refused if the person seeking to acquire the property doesn't provide convincing proof that it's not to be used for a secondary residence. However, Austrian nationals who have declared that they do not want to establish a secondary residence on the property they acquire are exempt from the requirement to obtain authorization. So that was the 1993 rule. And that changed in 1996. Under the new law, this is under the heading, the TGVG 1996, paragraph 4, under the new law too, authorization can't be granted if the person seeking to acquire the property doesn't provide convincing proof that it's not to be used to establish a secondary residence. The new law abolishes the exemption for the requirement to obtain authorization previously granted to Austrian nationals. Authorization must now be obtained by all persons seeking to acquire immovable property, irrespective of their nationality. It may also be granted under an accelerated procedure. We go to paragraph 12 on the FP 3702. you see his conclusion on this. Just above paragraph 12, it says the TGVG 1993 can therefore be regarded as existing legislation for purposes of the derogation. He says that because, as I say, the Constitutional Court had declared it unconstitutional. And he said, well, that doesn't make any difference. That was the law at the time. And then 12. In the second place, it must be borne in mind that the tax commission to which the Connolly case had been referred back after the Constitutional Court's decision of the 25th February 1997 was obliged to apply the TGVG 1996, which had superseded the TGVG 1993. That law, the most recent Tyrol legislation, entered into force on 1st October 1996, that is after Austria's accession to the Union. I should have explained this is dealing with an equivalent standstill provision dealing with the accession of Austria, but it's been taken as the template. You'll see that in FII. They repeat word for word the rulings here. Sorry, I should have mentioned that. So that law, the most recent Tyrol legislation, entered into force on 1st October 1996, that is after Austria's accession to the Union. The Austrian government contends that that law too is covered by the derogation. According to it, the TGGV 1996 made purely formal amendments to the system of the 1993 one, leaving the provisions of that law substantially unaltered. That view cannot, however, be accepted. The TGVG 1996, in fact, introduced different procedures from those laid down in the TGVG 1993 at the time of accession. In place of the declaration procedure reserved for Austrians and from 1st January 1996, persons enjoying the freedom of movement under the EEA agreement, the 1996 rules introduced a general obligation to obtain authorization and also allowed the competent administrative authorities to grant authorization to those acquiring the property in question under an abridged procedure. Thus, the two laws prescribed objectively different control procedures. Also, the abolition of the declaration procedure and the introduction of an authorization procedure for all applicants placed even greater restrictions on the transfer of immovable property, to the disadvantage of Austrian nationals and also of other nationals eligible for equal treatment under paragraph 3 of the 1993 law. So he's just saying there are different procedures introduced both for Austrian citizens and for non-Austrian citizens. And I read the passage from Mr. Justice Henderson's judgment saying you don't look at the fine details. I mean, how fine can you get? These really are fine details, and that's exactly what the Advocate General was looking at. We turn to the CJEU, begins at EFB 3712, but if we go to 3720, paragraphs 51 and 53. So it's 3720. '52 and 53, and this has become the template. These paragraphs are the template for the test of when a restriction is an existing restriction. 52. 51, just to say, as the court stated in paragraph 27 of its judgment, it's in principle for the Austrian courts to determine the content of the national legislation existing at the date of accession for the purposes of Article 70 of the Act of Accession. That's the standstill. 52. Any measure adopted after the date of accession is not by that fact alone automatically excluded from the derogation laid down in the Article 70 of the Act of Accession. Thus, if it is in substance identical to the previous legislation, or if it is limited to reducing or eliminating an obstacle to the exercise of community rights and freedoms in the earlier legislation, it will be covered by the derogation. On the other hand, legislation based on an approach which differs from that of the previous law and establishes new procedures cannot be treated as legislation existing at the time of accession. That's true of the TGVG 1996, which includes a number of significant differences when compared with the TGVG 1993, in which even if it brings to an end in principle the dual scheme of land acquisition which existed before, doesn't thereby improve the treatment reserved to nationals of member states other than Austria, since it also lays down detailed rules for examining applications for authorization, which are designed in practice, as the court stated at paragraph 41 above, to favour applications from Austrian nationals. So in that case, the first case dealing with the test to be applied for the standstill provisions, in that case, they looked at the changes both to the treatment for Austrian citizens and for non-Austrian citizens and saw that there were detailed procedural changes. The rules were not in substance identical, took a different approach, they involved different procedures. So that was the first case. That is the case that was treated as the template by the CJEU in the first of the FII hearings at the CJEU, which is Appendix 1B at tab 21. Yes, 1B. And pick it up, it would be at 190 to 192 as paragraphs, which is EFP 1567. As I mentioned, this was dealing with FIDs, the FID regime, which was introduced, whenever it was, 1993 or thereabouts, in order to alleviate the massive build-up of ACT, which had occurred since 1973, under the imputation system, which was operated, the credit system operated for overseas dividends. It was designed to alleviate it, but it introduced entirely new approach and new principles. And the question was whether the standstill applied so as to protect the UK government from its breach in respect of dividends from non-EU countries. So 190, 191, 189 on page 1567 is necessary, first of all, to clarify the concept of restrictions which exist on 31st December 1993 within the meaning of Article 57.1 EC. As the claimants, the United Kingdom and the Commission proposed, reference should be made to Connolly, in which the court had to provide an interpretation of the concept of existing legislation contained in a derogating provision in the Act concerning the conditions of accession of the Republic of Austria, the Republic of Finland, and the Kingdom of Sweden, and the adjustments to the treaties on which the European Union is founded, allowing the Republic of Austria to maintain its existing legislation governing secondary residences for a limited period. And now the test that's laid down. 191. While it is in principle for the National Court to determine the content of the legislation which existed on a date laid down by a community measure, the Court held in that case that it's for the Court of Justice to provide guidance on interpreting the community concept which constitutes the basis of a derogation from community rules for national legislation, in inverted commas, existing, those inverted commas, on a particular date. See to that effect, Connolly. 192. As the court stated in the Connolly case, any national measure adopted after a date laid down in that way is not by that fact alone automatically excluded from the derogation laid down in the community measure in question. If the provision is in substance identical to the previous legislation, or is limited to reducing or eliminating an obstacle to the exercise of community rights and freedoms in the earlier legislation, it will be covered by the derogation. By contrast, legislation based on an approach which is different from that of the previous law and establishes new procedures cannot be regarded as legislation existing at the date set down by the community measure in question. So it's word for word. Connolly has been applied by the CJEU in this very case. In this very case. So let's look at A. And this is reinforced by A. It's not undermined by it at all. Scatterbucket VA is in A2, Authorities 2, at tab 22 in the bound volume at EFP 3895. And if you look there on page 3895, just the title page, so to speak, you have a look, you'll see the judges in that case. This case was, if you look at our timetable, A was decided a year and a few days after FII CJEU 1. Have a look at the judges, the justices. You'll see you've got the President, Judge Skouris, Judge Yan, and Timmermans, Rosas, and Lennert's rapporteur. They were all part of the FII case, all part of the panel. Judge Lennert's was the rapporteur in FII, and he's the rapporteur in A. It would be puzzling if they took a different approach. As you will see, they didn't take a different approach. If we turn to Advocate General, it's either Bot or Beau, B-O-T, the late French Advocate General, at 3899. He explains, as is so often the case, you get more detailed in the Advocate General opinion. He explains what the case is about. So paragraph 2 on page 3899 says these proceedings are based on a dispute over the granting to a natural person living in Sweden of exemption from income tax in respect of dividends that were distributed to him by a company established in Switzerland in the form of shares it holds in the subsidiary. And then over the page at 3900, he sets out the national legislation in the middle of the page, headed national legislation. And the key provision is the very first sentence, para 9. Under Swedish law number 1229 of 1999, dividends paid to a natural person by a limited liability company are normally subject to income tax. Those words are key. That is the basic rule. Dividends are normally subject to income tax. And then you find that there was an exception to dividends of a certain type paid by Swedish subsidiaries. But that exception never applied to dividends paid by Swiss subsidiaries. They remain subject to the normal rules of income tax. So para 10, under paragraph 16 of chapter 42 of the Swedish law, dividends distributed by a Swedish limited liability company in the form of shares in a subsidiary aren't included in taxable income provided the distribution is made in proportion to the number of shares. So these are dealing with rights issues. If you drop down to para 11, those provisions entered into force for the first time in 1992 and apply only to profits distributed by Swedish limited liability companies. Those provisions were repealed in 1994 and then reintroduced in 1995. That was the only change. The only change that took place had nothing to do with dividends from Swiss companies. The question then was it sufficient that the change occurred in the comparator situation, the internal domestic dividends? Was that sufficient to bring the standstill to an end, to disapply the standstill? And here there was a disagreement, difference of opinion between the Advocate General and the court. The Advocate General said, well, looking at all the rules, there was a change. There was a change in the domestic ones, and that's appropriate. We can go to 3914. Where the Advocate General deals with the question of justification of the restriction. I'm not going to read it all through, but if you just note that it's quite interesting how this question arose. An awful lot of A is dealing with a totally different question about exchange of information. And what is an exchange of information requirement? Where you have a treaty that provides for mutual cooperation between tax authorities, but doesn't explicitly deal with exchange of information. So A is often cited in that. It's a very tedious point, nothing to do with us here. But the justification for the restriction, at paragraph 105, you'll see he says this: the local tax authority and the Swedish government, together with a number of other governments, maintain that the restriction at issue is justified by the need to guarantee the effectiveness of fiscal supervision. The Italian government, for its part, contends that that restriction is covered by Article 57(1) EC. That's the equivalent now of Article 64. So it was only the Italian government that raised this point and said, well, hang on, it's the same restriction. So it doesn't matter. So he then says, Advocate General, I shall begin by considering whether that restriction is an existing measure as referred to in Article 57, because if that's the case, there's no need to investigate whether it's justified on the basis of Article 58. And so he sets out the rules. And his conclusion, look at paragraph 111 on EFP 3915. In my view, therefore, the words restrictions which exist on 31st December 1993 presuppose that the legal provisions relating to the restriction in question have formed part of the national legal order continuously since 31st December 1993. He then refers to Conley. You'll see that at the beginning of 113. If we go to paragraph 115, however, at the bottom of page 3915, however, it's not apparent from the grounds of those judgments or from the context in which they were delivered that the concept of existing restrictions can also apply where legislation that was in force at the relevant date has been repealed and then reintroduced into the national legal order sometime later. In Conley's case, the test claimants in FII, and Holbeck's case, the contested legislation constituted an amendment to the legislation in force at the relevant. In those cases, there was no time when, as in the main proceedings, the original restriction had been removed from the national legal order and the contested legislation had not yet entered into force. So over the page, 116, 117, it says, nor have I found in the court's judgments interpreting the concept of existing legislation in a legal context, other than direct taxation, any example to contradict my view, and therefore of the opinion that the restriction at issue in the main proceedings can't be justified. In other words, he thought that the fact that there was an interruption in the way in which Swedish companies had been granted an exemption brought the standstill to an end, even though there was no change in the regime applying to dividends from Swiss companies, the impugned regime. We go to the CJEU, they didn't take that approach. They just looked at the restriction applying to the dividends from Switzerland and said there's been absolutely no change. So if we go to the CJEU, the judgment begins on EF page 3922. And then they set it out, the various facts. And if we go to 3928, paragraph 41, we get to the meat here. And as I say, this is really important because it's Justice Henderson and the Court of Appeal heavily relied on A, and A features very heavily also in the HMRC's written case, in this case too. So let's look at paragraph 43 on page 3928. Legislation such as that at issue in the main proceedings therefore entails a restriction on the movement of capital between member states and third countries, which in principle is prohibited by Article 56, now Article 63. And then before examining whether as the local tax authority and the governments which submitted observations, the court maintained that restriction may be justified by an overriding requirement of general interest, it's necessary to address the argument put forward by the Italian government that that restriction is covered by the exception provided for in Article 57(1)(c). And then whether the exception provided for applies. I think we can pick it up at paragraph 47. Since the order for reference doesn't preclude the possibility that the dividends which Company X is contemplating distributing to A relate to such investments, that's whether these were direct investments, it's necessary to examine whether legislation such as that at issue in the main proceedings may fall within the exception provided for in Article 57(1 as a restriction which existed on 31st December 1993. As Advocate General Bott pointed out in paras 110-112 of his opinion, the words restrictions which exist on 31st December 1993 presuppose that the legal provision relating to the restriction in question have formed part of the legal order of the member state concerned continuously since that date. If that were not the case, a member state could at any time reintroduce restrictions on the movement of capital to or from third countries which existed as part of the national legal order on 31st December 1993 but had not been obtained. The court expressed a similar view when called upon to rule upon whether the exception provided for in Article 57(1 was applicable to restrictions on the movement of capital which existed in the legal order of a member state on 31st December 1993. While the court accepted that any national measure adopted after that date isn't by that fact alone automatically excluded from the derogation laid down in Article 57(1, it understood that possibility to encompass provisions, and here we have again the repeat of the template, to encompass provisions which in substance are identical to previous legislation or which are limited to reducing or eliminating an obstacle to the exercise of community rights and freedoms in the early legislation, whilst excluding provisions based on an approach which differs from that of the previous law and establishes new procedures. See to that effect the FII case and Holbeck. In doing so, the court did not have in contemplation provisions which, whilst in substance identical to legislation which existed on 31st December 1993, reintroduced an obstacle to the free movement of capital which, following the repeal of the early legislation, no longer existed. In the present case, on the date of its entry into force in 1992, Para 16 of Chapter 42 of the law already provided that dividends paid by companies established in the third country, which hadn't concluded a convention providing for the exchange of information with Sweden, were precluded from the exemption provided for dividends distributed in the form of shares in a subsidiary. It's apparent from the order for reference that at that date, that exemption applied only to dividends paid by companies established in Sweden. Admittedly, the provisions on exemption were repealed in 1994, then reintroduced in 1995 and extended in 2001 to dividends paid by companies established in an EEA member state or in another state with which Sweden has concluded a convention providing for the exchange of information. However, the fact remains that, as the Italian government contends, that exemption was removed continuously, at the very least with effect from 1992, for dividends paid by companies established in a third country outside the EEA, which has not concluded such a convention with Sweden. In those circumstances, the preclusion since 1992 from the exemption provided for by the law of dividends paid by a company established in a third country outside the EEA, which has not concluded a convention with Sweden providing for the exchange of information, must be regarded as a restriction which existed on 31st December 1993 within the meaning of Article 57. Now, as is always the case with the ECJ, long-winded sentences, but the point is so simple. He says they were always excluded from the exemption. In other words, they were always chargeable to tax. Nothing changed. Nothing changed so far as the taxation of dividends from Sweden, from Swiss companies was concerned. Nothing changed. Not one jot. In substance, identical. Actually identical. How can that be said to be the case in the present? Where everything changed so far as the method and amount of method to be given when computing the credit that can be taken into account, and the amount of credit itself was restricted. So those are the cases there. And I think if we can just look, we can find the Court of Appeals decision on this. Hopefully I have it. It's in Appendix 1B at tab 2.
I think those of us working on the electronic bundles will find it at page 723.
723. It is indeed, my Lord, I'm grateful, and it is in Appendix Volume 1A, and we can pick this up at, I think it is 755. Yes. And that's the heading. If the provisions of Case 5 are scheduled to infringe Article 56 in principle, are they permitted by virtue of the standstill provisions in Article 57 in light of the eligible and relief foreign tax rules? And then if we turn over the page, 756, community law requires that derogation in Article, para 74, community law requires the derogation in Article 57 to be interpreted strictly, since it's a derogation from the fundamental principle of the free movement of capital. And then under the citation, it's common ground that in identifying the relevant restriction and answering the question whether it remained continuously in force on 31st December 1993, the matter should be considered from BAT's point of view. Now, pausing there, they've got it absolutely right. You have to consider this from BAT's point of view. And you apply those 4 tests. In substance identical. Is it designed to alleviate new procedures, new approach, from BAT's point of view? And then we have in paragraph 79 on page 761. The effect of the UFT regime was that the mixing had to be done onshore to obtain the most effective tax relief benefit. One of the problems was that it wasn't possible to mix onshore dividends paid by CFCs, controlled foreign companies, which paid those dividends for the very purpose of complying with the CFC rules. And then to drop to the bottom sentence, last sentence of that para, it wasn't possible, therefore, to set off dividends paid out of profits with higher rates of tax against those from CFCs, which would have borne lower rates of tax. And then para 81, the implications of these changes in the new regime for the VAT group were summarised by the judge in para 107 of his judgment, which we've set out above. And I think I took you to those. And turn over the page and we'll see where they went wrong. Para 83. Mr. Aronson submitted that the issue under Article 57.1 in the present case was whether the Case 5 charge, if there was no exemption under ICTA Section 208, changed significantly as a result of the UFT regime. That is to say, whether the practical effect of the UFT rules was to impose a significantly different tax regime. He submitted that it was clear that such a test was satisfied because the new legislative approach introduced a new restriction as to offshore mixing, and it excluded dividends paid out of profits that had been subject to low rates of tax. The practical impact on the BAT group, described in para 107 of the judge's judgment, showed clearly he submitted that the Conley test was satisfied in the circumstances. The changes brought about were significantly greater than those held in Conley to have established new approach to the law and new procedures. The judge's conclusion that the Case 5 charge was still in substance the same after the introduction of UFT was, he submitted, plainly wrong. Attractively as those submissions were made, I'm always happy to receive flattery, but I'd rather have had the right decision. But attractively as those submissions were made, we reject them. We consider that the judge's analysis in para 99 of his judgment was correct. Article 56 prohibits restrictions on the movement of capital between member states and between member states and third countries. Article 57.1 exonerates those restrictions which existed on 31st December 1993 that would otherwise contravene Article 56. On the hypothesis that the ECJ holds in favour of the claimants on issue 1, and this is the point I made right at the beginning, on the hypothesis that the ECJ holds in favour of the claimants on issue 1, that's going back to the ECJ, reference back as to whether the restriction now did breach the freedom of movement to capital on the basis that the cases were not exceptional, that the cases where reliefs did not flow through occurred in the majority of cases. So he says, on the hypothesis that the ECJ holds in favour of the claimants in issue 1, the contravention of Article 56 was the exclusion of third country source dividends from the exemption conferred in respect of domestic source dividends by ICTA Section 208. That exclusion existed on 31st December 1993. Takes you back to the chronology. At that stage, the assumption of Mr. Justice Henderson, the assumption of the Court of Appeal, was that if, on going back to the CJEU, we say, hey, you got it wrong last time, these cases were not exceptional, these cases were the norm, they would say that the exemption system had to be applied. That was the assumption, and indeed, that's what the Advocate General himself, Jeskinen, thought was correct in CJEU 2. He thought that was the right approach. So on that assumption, you could say, well, the exclusion from exemption was the restriction, and that never changed. You've always excluded from the exemption. So that's where they went wrong, which was not really their fault, the Court of Appeal, because of the timing. And then they have an alternative method, para 85, where it just is wrong. There's an alternative way of looking at the matter with the same results. Paras 49 and 50 of the ECJ's judgment in this case specify the minimum requirements of an exemption imputation system in order to be compatible with community law. First, the foreign source dividends must not be subject to the member state to a higher rate of tax than the rate applies to domestic source dividends. Secondly, the member state must prevent foreign source dividends from being liable to a series of charges to tax by offsetting the amount of tax paid by the non-resident company making a distribution against the amount of tax for which the recipient company is liable, up to the limit of the latter amount. If there was a violation of Article 43 or Article 56 in this case, it was that the effective rate of tax applied to domestic source dividends could and would normally be lower than the rate on foreign source dividends. It's that which falls for consideration under Article 57.1. That restriction existed on 31st December 1993 and continued unchanged subsequently. Now, with respect, that isn't looking at the detail, that's just a broad generality. You say, well, generally you were worse off and you remained worse off. The critical points we've seen from Connolly, as we've seen from FII, and as we've seen from A, is you have to ask if the rules were identical, or if they made you better off, or if they had new procedures, or if they had a new approach. Not looking at it very broadly, well, you didn't get the benefit of your reliefs allowed before, you don't get your benefits of relief now, nothing's changed. I mean, that's just too superficial with bits. The introduction of the youth regime had nothing to do with that restriction. That's ridiculous. Of course, it had everything to do with that restriction. Sorry, I take back the word restrictless. That is the erred in so stating. Of course, it had everything to do with restriction. In the detail of the restriction, it made it worse. The general description of the description is right, but not the operation. The introduction of the youth regime had nothing to do with that restriction. It was directed at the way in which credit was to be calculated and given for the amount of tax paid by the non-resident company making the distribution against the amount of tax for which the recipient company is liable up to the limit of the latter amount. It was concerned only with the requirement described in para 50 of the ECJ's judgment in this case and obligatory under the parent subsidiary directive. It's not suggested that such requirements cease to be satisfied by virtue of the youth regime. The principle remained as before. The principle remained as before that there was double tax relief for all tax paid by foreign companies, subsidiaries on profits distributed subject to the limit of United Kingdom corporations. Well, of course, the principle remains, but that's not the test. The test was the restriction the same. The principle was the same. The practice was very different. It was designed to be different. So 86, as Mr. Hewitt submitted, the United Kingdom system, both before and after the youth regime, went further than was required by community law in at least two respects. It gave relief for underlying tax down the chain of corporate subsidiaries, and it permitted excess relief to be transferred across the corporate structure and to be used to offset other dividends. In short, the youth restrictions altered the way that tax credit was to be calculated, but that had nothing to do That had nothing to do with the restriction which, subject to Article 57(1) and on the hypothesis that the claimants are correct about issue 1, infringed Article 56. You could only say it had nothing to do with it if you were focusing entirely on what they thought was now the correct approach, that there wasn't exemption, that exemption should have been granted. There wasn't. So 87, the effect of Mr. Anson's analysis is to treat the whole of the case 5 charge as comprising relevant restriction, which in our judgment is wrong. There's no way did I submit that the whole of the case 5 charge was the relevant restriction. What I said, what was the relevant restriction, was that the amount of credit that was being allowed was being restricted, and it was being restricted further and further. And the youth rules just made it more and more restricted. End of story. So I had intended to finish this at about 11:45. I've overrun by a couple of minutes. I don't know, my lord, if you want to take a 5-minute break at this point before I move on to shareholder credits.
That seems like a convenient moment. Thank you very much, Mr. Aronson. We'll resume then in 5 minutes' time.
I'm obliged.
No, I think we're ready to resume. Mr. Aronson.
My lords, shareholder credits issues 17 domestic law and 18 EU law. They're dealt with extensively in our written case. This is an important issue. And just to refer, the references in the core volume 1, tab 9, at paras 37 to 81, EF pages 394 to 408. And we set out our arguments in detail there, and we adhere to those arguments. But let me approach this slightly differently at this stage. On this point, we have succeeded both before Mr. Justice Henderson and in the Court of Appeal, in unanimity of views. HMRC have tried very hard to get permission to appeal against the analysis and decision of the Court of Appeal in the first hearing, but the credit which has to be allowed for overseas tax, now at the foreign normal rate or the actual amount, whichever is higher, is a section 231 credit. HMRC sought permission to appeal against it. It was their own submission back in the early days. They realised the implications of that are not very helpful when it comes to cases at this particular point and other points like it. So they've sought permission to appeal against that, and your court has explicitly turned down that application to appeal. Why have they fought so hard? Because they cannot begin to make a case. They cannot begin to make a case. They cannot succeed in a case once it is accepted that the credit to be allowed for the overseas tax constitutes a section 231 credit. As soon as that is introduced into the system, you do not have a normatively defective payment of shareholder credits. It doesn't matter whether ACT is actually paid. What matters is whether the system providing for the credit to the shareholders operates correctly, and it does operate correctly, because the foreign credit, the foreign tax credit, is the equivalent of franked investment income, and the system works as it was designed to work. There's nothing normatively defective about the payments to the shareholder. That, in a nutshell, is what the whole case is about, which is why we've succeeded at every stage. I'll be going through my learned friend's arguments because we're responding to his case here, and I'll be dealing with Pirelli, etc., to show how that is very different. But by way of introduction, let's accept, because it is correct, that EU law has introduced two cuckoo's eggs in the nest. In the case of Pirelli, the cuckoo's egg in the nest was that a group income election under Section 247 should be allowed even where the parent company was resident outside the UK. Section 247 wasn't designed to operate that way, but it's been made to operate. The consequence of that is quite straightforward. The legislation operates in the way it operates. Where you have a Section 247 election, you do not have a Section 231 credit. Where you do not have a Section 231 credit, you can't pass the credit on under a treaty or whatever. It just follows. The case was argued very hard because everything was in its early formative stages. The universe was still, the firmament hadn't really separated very clearly between land and sea, and etc. Everyone was groping their way at that particular time. And we'll see that when we look at our judgment chronology. The cuckoo in the nest, in our case, is quite different. And that is that the foreign nominal rate was never intended by the architects of the UK FII, Franked Investment Income Scheme, to be taken into account as franked investment income. Never intended. But you have to. And once you do that, everything just flows through. So they're the two cuckoos in the nest, or the two variants which EU law introduces. And they each have their statutory consequences. And the statutory consequence here is that there is absolutely nothing wrong, nothing objectionable in the payment of the shareholder credits. That's how our system works. Now, to there's a bit of an irony in this, to step back and look at it broadly, which I said you shouldn't have done in the context of youth, but to step back and look at it broadly, you also have to see what it is that these ECJ decisions have been all about. They've been about the regime introduced in the United Kingdom to mitigate economic double taxation. And we're dealing with ACT and these issues of shareholder credit. What does that mean? It is the very system designed to prevent a double charge, one on a company making a distribution, and two on the shareholders ultimately receiving that distribution. That's what the FII regime was designed to achieve. It's to ameliorate, to alleviate economic double taxation. Ex hypothesis, it is dealing with the credit received by the shareholder. It's the whole purpose. And all that has happened, and it's a huge all, but all that has happened is that foreign tax at the foreign nominal rate has to be treated as part of that system for passing the benefit through to the shareholders. That's what the EU law is all about. There's nothing objectionable about it. That's what it's designed to achieve. And that's what's achieved in the wholly domestic system. Wholly domestic system, profits are charged to tax in the company, it can be the bottom company. The shareholder at the top gets the credit. If he's a standard rate taxpayer, he doesn't pay tax. If he's an exempt fund, if it's an exempt fund, it gets the tax. And the same happens where the profits are made overseas and not in the UK. That's what this whole case is about. We have been arguing now for 14 years, since 2006, with the ECJ, HMRC have raised the same argument over and over again and raised it yesterday. It's been rejected 3 times by the ECJ, by the CJEU. They say the shareholder only gets the credit of ACT is that all the system is designed just to have ACT being paid once. It's nothing to do with it. It's not has nothing to do with it. That's not the whole story at all. It's a tiny part of the story. That submission was made in 2006, ECJ1, 2012, CJEU. It was made again by the United Kingdom in the trustees of the BT Pension Fund scheme, which my then friend mentioned but didn't actually get to, whether he ran out of time or decided not to mention it, I don't know. Same submission made 3 times, each time explicitly rejected. So that's really, in a nutshell, why we have succeeded below. The revenue cannot succeed from this point once it is accepted, and it has to be accepted, that the credit for overseas tax is a 231 credit that feeds into the system for alleviating economic double taxation. If we look at the judgment chronology, you see the first other domestic case is Pirelli. Pirelli case was decided on the 8th of February 2006. It was before the first reference decision in this case. It was before ACT Class 4. The Pirelli case had nothing to do whatsoever with tax credits. No one suggested in Pirelli that EU law gave anyone the right to a tax credit. What EU law did, as a result of the Hearst decision, Pirelli was an offshoot of Hearst. It was Class 2 of the ACT case. Hearst was Class 1, I think. That turned into Sempra, which was the other name for Metalgas offshore. What Pirelli was concerned about was solely the question whether a double tax, whether a group income election could be made. Nothing else. And what is the consequence of it? It's actually a much simpler case. It's, as I say, historically, it was hard fought because we were all trying to understand what the European law was requiring. But at no stage in Pirelli was it suggested that there was any mandate from Europe giving anyone the right to a credit. If you look just below it, you'll find it forms a triangle. On the left-hand side, you have FII CJEU 1 on the 12th December on the same day, ACT Class 4. These were 2 sides of a coin. ACT Class 4 asked the question whether a credit was required to be given where you had a UK company paying a dividend to a foreign shareholder, an EU shareholder. Was a credit required? Why? Because we say, well, tax was paid by the UK company on its profits, and that credit should be given to another EU, to an EU recipient. And we lost that case. Simple as that. Decision given on the same day by exactly the same court, saying, no, there's no credit in that direction. You don't get a credit. But you do in FII, you get a credit for the underlying tax paid in an EU state. That credit you do get, that credit feeds into the system. Had it gone the other way, then Pirelli probably would have been wrongly decided, probably would have had to be referred to Europe. It didn't go the other way. So that's in a very broad outline is why Pirelli has no relevance here, except in one respect, which is a very helpful respect, which is follow the legislation. Pirelli followed the legislation. It looked at section 247. It said, what's the consequence of section 247? Consequence is section 231 doesn't apply. I'll take you to the statutory provisions. There was one little bit of section 247 or 231, which my learned friend didn't read. I'm not saying deliberately, but it was quite important, and I will read it. So let's have a look at the key provisions, key elements of the case law that's being developed here. And if we start with the first Court of Appeal decision, which is in Appendix 1A at Divider 2, in paragraph 97, which I hope 766.
Page 766.
I think it's 766 I'm looking for. Yes. And then paragraphs 105, that's where they introduced this. Well, look at, while we're on 766, they've reworded the issue of Paras 97. We've reworded this issue to make it clear that this question is about conforming interpretation. That is the question whether the ACT provisions can be read in a manner which is compatible with community law as declared by the ECJ in this case. And then if we go to paras 105, 107 to 107, that's 768. 105, we do not consider that the principle of effectiveness affects the interpretation of a statute in circumstances such as arise in the present case. All the court is entitled and bound to do is to see whether section 231 can be read so that the right to a credit which is conferred extends not only in the circumstances expressly mentioned in section 231, but also takes into account the rights of persons under community law. Once that question is answered and the interpretation is given, the task of conforming interpretation is at an end. And then 106, there is a further reason for rejecting the claimant's submissions that section 231 as interpreted on the lines set out in the foregoing paragraphs would contravene the community law of effectiveness. So we were arguing against this. We said there should be full exemption. And they were saying no, or not full exemption. We were saying that the foreign dividend itself should automatically be taken in its entirety as franked investment income. And they said no, the credit is a credit that comes in under 231. And then para 107, it therefore falls to this court to determine the appropriate conforming interpretation. In our judgment, a conforming interpretation can be achieved simply by reading in words that make it clear that resident companies can claim a credit under section 231 in respect not only of qualifying distributions made by resident companies, domestic source income, but also distributions made by other companies, foreign source income, to the extent that community law requires a tax credit to be given in respect of that income. That's the key finding. It's in their order, which is at tab 1 of this bundle. It's order 5 at page 716. The respondent's appeal on issue 6 is allowed. Declaration 5 is set aside and replaced with the following. Insofar as the ACT regime is incompatible with Article 43, the appropriate way to ensure compliance with EU law is by reading in words to make it clear that resident companies can claim a credit under section 231 in respect not only of qualifying distributions made by resident companies, domestic source income, but also distributions made by other companies, foreign source income, to the extent that community law requires a tax credit to be given in respect of that income too. The extent of that entitlement can then be investigated when the section falls to be applied. Now, we know from ECJ2 what extent community law requires the credit to be given. It's the FNR, foreign nominal rate, or the actual tax, whichever is the higher. And then if one looks over at page 717, further order, Order 1 is varied, para 16. Order 1 is varied to read: the following claims are successful in relation to the GLO issues determined in the trial. Claims for the repayment of surplus ACT or the time value of ACT utilised against corporation tax or ACT refunded under the FID regime paid on or after 1st January 1973 by claimants which received dividend income from subsidiaries established in other member states, insofar as while the ACT paid was not due after taking into account the tax credit available under Section 231 ICTA 1988 in respect of those dividends. So that is the basic building block we have to work with. And as I say, if you look down this judgment chronology, you'll find on 8th of April and 27th of June last year, your orders on the commission hearings, and you refuse HMRC permission to appeal against that conclusion of an order of the Court of Appeal. So if we look at the reasoning given in the second Court of Appeal, and that's in Appendix 1A, 4 at 904. They deal with this issue at paras 243 and 255, which is at 904, I believe. I got it right. So issue 17 at 904. Were HMRC enriched by the payment of ACT when it was required to give corresponding tax credits to the recipients of the dividends? And then the key paragraphs for 247 and 248 on EFE 905. In our judgment, HMRC's case is successfully met by Mr. Aronson's principal submission on this issue. He submits that there's no proper analogy with Pirelli. In Pirelli, what was lost by the breach of EU law relied upon was the ability to make a group income election that meant that no ACT was payable. It followed inexorably from that. In such a case, Section 231 meant that no credit was obtained. But here the position is different. The vice that EU law seeks to cure is the failure to treat EU companies with EU subsidiaries in the same way as UK companies with UK subsidiaries. If they had been treated equally, the ACT on the distribution up to the shareholders would not have been payable because the EU subsidiary had paid its foreign corporation tax. But if the foreign corporation tax is to be treated as UK ACT, then the UK company to whom the dividend was paid by the EU subsidiary would have obtained an ACT credit, and that credit would have passed on to the shareholders receiving the ultimate distribution. Thus, the ACT paid in this situation is not properly analogous to the ACT paid in Pirelli, where the double taxation tax credit was, as a matter of construction, inextricably linked with the payment of the ACT. Here, the tax credit granted to the shareholders is properly to be regarded as a matter of EU law, as the quid pro quo, or what Mr. Aronson called the reciprocal for the payment of foreign corporation tax at the bottom of the chain by the EU subsidiaries. And then 248, it should of course be noted that this argument depends on EU law, when the question being determined is one of English law. But that's only because one is asking the English law question of whether HMRC were truly enriched at the expense of the claimants. And to answer that question, one has to consider the reason why the credit was given. If the credit would have arisen even without the payment of ACT in the reformulated world of compliance with EU law, then it follows that it can't be set off against the proper value of the restitution HMRC must make. So that is wholly correct, great respect, exactly for the reasons given, and it is a complete answer to this issue. Just to I wouldn't say make that good, but just to expand it a bit, we look at the relevant legislation. My learned friend took you through it. It's in A1, it's authorities 1 attack 3. We should look at section 231 again. That's at 3078. And 231, which is absolutely key because you have to read 231 before you get to the critical provision, which is section 241. 231, subject to sections 247 and 441A, where a company resident in the UK makes a qualifying distribution and the person receiving the distribution is another such company, or a person resident in the UK, not being a company, the recipient of the distribution shall be entitled to a tax credit equal to such proportion of the amount or value of the distribution as corresponds to the rate of advance corporation tax in force for the financial year in which the distribution is made. The recipient of the distribution shall be entitled to a tax credit. That's what it says. If you turn to 24, actually let's go to 238, which is at 3086. And it was here that my learned friend didn't read the last few words. It's the definition of franked investment income. 2381. Franked investment income means income of a company resident in the UK, which consists of a distribution in respect of which the company is entitled to a tax credit, and which accordingly represents income equal to the aggregate of the amount or value of the distribution and the amount of that credit, but subject to 2472. So this reinforces, my learned friend didn't read those words, I don't think, or I didn't hear them, if he did. So you don't get FII, you don't have franked investment income if a section 247 election is in place. And that's what Pirelli was all about, as I said. But you do get franked investment income where you don't have a section 247 election. And what's the effect of having franked investment income? Remember, the foreign credit is treated as a credit for 231. What is the effect? The effect is quite straightforward. It simply feeds into the operation of section 241 at section 3090. And this tells you how much ACT has to be paid. Sometimes you don't pay any ACT at all because you have a surplus of franked investment. But the credit feeds through to the shareholder under section 231. 241, where in any accounting period a company receives franked investment income, the company should not be liable to pay advance corporation tax in respect of qualifying distributions made by it in that period, unless the amount of franked payments made by it in that period exceeds the amount of that income. If in an accounting period there is such an excess, advance corporation tax should be payable on an amount which, when the advance corporation tax payable thereon is added to it, is equal to the excess. It's so straightforward. You only pay ACT to the extent that your payments out, the dividends out to shareholders, are greater than the amount of your franked investment income. You only pay ACT in those circumstances. So to say that the credit received by the shareholders has been wrongly received, if you like, because ACT wasn't paid, it just misses the point by a mile. If you have a legitimate tax credit coming from overseas, feeds into the system, you do not pay ACT if you pay the same amount out by way of dividend to your shareholder. It's as straightforward as this, and the shareholder gets them. There is nothing normatively defective in the shareholder getting the credit if it turns out that no ACT was paid. The shareholder credit is not determined by the amount of ACT that is paid. Shareholder credit is given by 231, and the amount of credit of ACT that is paid is specified in section 2.4. Now, that's looking just at our legislation. As I said in opening, that you have to see this in the context of what the case is all about, which is the amelioration of economic double taxation, which by its very nature, by its very definition, involves passing on the benefit of tax paid at the corporate level to the shareholders. At the corporate level to the shareholders. ACT, in a wholly domestic thing, was one of the mechanisms used. But the concept of alleviating economic double taxation is to reduce the tax charge on the shareholders by reference to the tax paid on the underlying profits by whatever company paid. And thanks to 2 visits to the CJEU, we know that that includes overseas tax. We can pick this up very clearly in the first reference. It's FII CJEU 1, Appendix 1B, at tab 20, EFP 1487. And I'm reading here from the opening paragraphs of the late Advocate General Pierre Hood, the Dutch Advocate General, who I think had been finance minister in the Netherlands, and really understood taxation, economic double taxation. So we reread paragraphs 2 to 6, EFP 1487 onwards, and I'll read it out rather than inviting you because I will fillet it as we go. Paragraph 2. Prior to setting out the relevant provisions of the UK tax regime at issue, it's important to outline the broader framework for taxation of distributed company profits, dividends within the EU, which forms the legal and economic backdrop to the case. In principle, 2 levels of taxation can arise when taxing the distribution of company profits. The first is at the company level in the form of corporation tax on the company's profits. The levying of corporation tax at company level is common to all member states, and that's quite important. It's common to all member states. And you'll find that's why they treat corporation tax anywhere as the same, whether it's in the UK or overseas. The second is at the shareholder level, which can take the form of either income taxation on receipt of the dividends by the shareholder, a method used by most member states, or by withholding tax to be withheld by the company upon distribution. The existence of these 2 possible levels of taxation may lead on the one hand to economic double taxation, taxation of the same income twice in the hands of 2 different taxpayers, and on the other hand, juridical double taxation, taxation of the same income twice in the hands of the same taxpayer. Economic double taxation arises when, for example, the same profits are taxed first in the hands of the company as corporation tax and second in the hands of the shareholder as income tax. That's what this whole case has been about. Juridical double taxation happens when, for example, a shareholder suffers first withholding tax and then income tax levied by different states on the same profits. 4. The present case concerns the legality under community law of a system set up by the UK with the principal aim and effect of providing a measure of relief for shareholders from economic double taxation. That's how the ECJ viewed, or how the Advocate General viewed this issue. Case concerns the legality under community law of a system set up by the UK with the principal aim and effect of providing a measure of relief for shareholders from economic double taxation. And then in para 5, he says how there are different systems. And if you drop down to the bottom of para 5, finally, under the imputation systems, corporation tax at company level is fully or partially imputed onto the income tax due on the dividends at shareholder, such that the corporation tax serves as a prepayment or part of this income tax. Thus, shareholders receive an imputation credit for all or part of the corporation tax attributable to the profits out of which the dividends were paid, which credit can be set against the income tax due on these dividends. 6. At the time relevant to the present case, the United Kingdom used a partial imputation system of dividend taxation. What the whole case was about: imputing the corporation tax paid here, overseas, in other member states, to the shareholders, so that they get a credit against their income tax. So that's what the Advocate General said. We go to the court, 15, I think this is behind tab 21, 1554. This issue is taken up. I think we go to the easiest place to go is paras 85 to 94, which are on pages 155, 1555 and 1557. And we can pick it up at paragraph 85. According to the United Kingdom government, that difference in treatment doesn't constitute discrimination prohibited by community law, since it's not based on a distinction between nationally sourced dividends and foreign sourced dividends, but between dividends on which ACT has been paid and those on which no ACT. The tax credit granted to a resident company receiving dividends from another resident company is designed to prevent economic double taxation in the field ACT. This was HMRC's argument. Since in the case of a company receiving dividends from a non-resident company, no ACT has been paid by the latter, there's no risk of economic double taxation as regards ACT. Then their conclusion. Whilst it is true that under the national legislation at issue in the main proceedings, the amount of ACT which a resident company is pay on a distribution by way of dividend to its own shareholders depends on whether that company has or has not received dividends from a company which has already paid ACT, the fact remains that that system leads in practice to a company receiving foreign source dividends being less favourably treated than a company receiving nationally sourced dividends. On a subsequent payment of dividends, the former is obliged to account for ACT in full, whereas the latter has to pay ACT only to the extent to which the distribution paid to its own shareholders exceeds that which the company has itself received. Contrary to what the United Kingdom government contends, a company receiving foreign source dividends is seen in the light of the objective of preventing the imposition of a series of charges to tax, which the legislation at issue in the main proceedings seeks to avoid. It is in a comparable situation to that of a company receiving nationally sourced dividends, even though the latter receives dividends on which ACT has been paid. And then you will drop down to para 90. That being the case, the fact that a non-resident company has not been required to pay ACT when paying dividends to a resident company cannot be relied on in order to refuse that company the opportunity to reduce the amount of ACT which it is obliged to pay on a subsequent distribution by way of dividend. The reason why such a non-resident company is not liable to ACT is that it's subject to corporation tax, not in the United Kingdom, but in the state in which it's resident. The company can't be required to pay in advance a tax to which it will never be liable. And then para 94, it follows, at the foot of the page, that Article 43 precludes a national measure which allows a resident company which has received dividends from another resident company to deduct the amount of ACT paid by the latter company from the amount of ACT for which the former company is liable, whereas a resident company which has received dividends from a non-resident company is not entitled to make such a deduction in respect to the corporation tax which the last mentioned company is obliged to pay in the state which it's resident. And then if we look at their answer to the issue in relation to FIDs, and here this is instructive for two reasons. First, there is again an explicit rejection by the ECJ of HMRC's primary submission, which is that credit given for ACT is only against ACT which has been paid. It's credit against ACT is only if there's been ACT paid. It's what I was saying to you yesterday looking at these diagrams. It's the same argument they've run and has been rejected. That has been rejected in the context of FIDS explicit. But equally importantly in FIDS, the court points out that the FID regime, the foreign income dividend regime, deprived shareholders of credits. And that was regarded as a relevant extra restriction in the context of the standstill provision. So again, it was looking at the shareholders. But the FIDS, we look at the passage there, it's at 1562. And you see question 4 of the FIDS, 1562, para 140. By question 4, the National Court essentially asked whether Articles 43 and 56, together with the directive, preclude national legislation, such as the legislation issued in the main proceedings, which, while allowing resident companies receiving foreign source dividends to elect to recover ACT accounted for in the subsequent distribution of their own shareholders, first obliges those companies to pay the ACT and to reclaim it subsequently, and secondly, does not provide any tax credit to their shareholders, whereas those shareholders would have received such a tax credit if the resident companies had made a distribution based on national source. And then if we go over the page, from paragraph 150 onwards, it states the United Kingdom's argument that those differences in treatment don't involve any restriction, and the conclusion of the ECJ is at page 1564 at paragraphs 158 and 159. As regards the fact that shareholders are not entitled to a tax credit under the FID regime, the United Kingdom government argues that such a tax credit is granted to a shareholder receiving a distribution only when there's economic double taxation of the profits distributed, which must be prevented or mitigated. That doesn't apply to the FID regime, in as much as first, no ACT has been accounted for on the foreign source dividends, and secondly, the ACT which the resident company receiving those dividends must account for on making the distribution to its shareholders is subsequently repaid. So there they're dealing with the argument that the tax credit given to a shareholder. HMRC says, no, that's not in breach because ACT isn't paid, or if it is, it's 159. However, that argument is based on the same false premise, that a risk of economic double taxation arises only in the case of dividends paid by a resident company subject to an obligation to account for ACT on dividends distributed by. Whereas the true position is that such a risk also exists in the case of dividends paid by a non-resident company, the profits of which are also subject to corporation tax in the state in which it's resident, at the rates and according to the rules applying there. So that's...
Mr. Aronson, can I just clarify an aspect of the facts, just to make sure I'm understanding this correctly? Your client's basic complaint, as I understand it, so far as ACT is concerned, is that they had to pay ACT, which they wouldn't have had to pay if they had received an adequate, that's to say non-discriminatory, tax credit in respect of their dividend from foreign subsidiaries. That's right?
Yes.
Yeah. And they're seeking to recover the excessive ACT that was paid.
Yes.
They're putting it very simply. Are they also now receiving foreign tax credits on the same dividend income?
I'm sorry, I didn't quite follow the last question.
well, they complain that the treatment of the foreign dividend income under double taxation treaty was discriminatory because it was less generous in practice than the treatment of domestic dividend income. And the solution, we've been told, is for foreign tax credits to be allowed, calculated on the basis of the foreign nominal rate of tax.
Yes, or the actual rate if it's higher. Yes.
Yeah, yes. All I'm wondering is, are the companies who paid the ACT on the foreign dividend income now entitled to receive foreign tax credits calculated on the proper basis?
When you say now, you mean for the years in question?
Yes.
Yes, that's exactly that's what they should have. Section 231 and Section 241 should have operated by taking into account the overseas tax paid at the foreign nominal rate.
Yeah.
And had that been done, then they would not and should not have paid ACT to the revenue, because Section 241 tells you that you only pay ACT to the extent to which your franked payments exceed your franked investment income, and they wouldn't have exceeded franked investment.
And so now that they are entitled to for the years on the income, in respect of the income that was received for the years in question, what do they do with those tax credits?
Well, let's assume we go back in time and that before the tax returns, the self-assessment returns were filled in, we had all the answers from the ECJ. Mm-hmm. So everything was put in suspense and they filled it in. What they would have done in their return, the CT61 return, which we heard about, and that's exactly what that's what the spreadsheet, which went before Mr. Justice Henderson the second time round, was all about. It was saying, well, let's assume we got it right. What we would have done is we looked at the dividends coming from overseas. We see what tax credit they would cover, see what tax was paid at the foreign nominal rate or the actual rate if higher. We put that into the CT61 return. And then when dividends are paid out, we see whether the dividends being paid out, the franked payments as they're called, were greater in amount than the franked investment income that's come in. And if it's greater, we pay ACT, and if it isn't greater, we don't pay ACT.
Yeah.
And well, I was going to come to this at the end, but maybe this is a convenient time to do it. Let's assume that the test claimants or any other of the 25 groups here, that their tax departments had actually they thought they knew what the tax law was, and they did exactly that in their actual return at the time. And they said to themselves, well, actually, we shouldn't be paying any ACT, but because the domestic legislation doesn't have these rules, we're going to pay the ACT now rather than risk a penalty. But we're filling in our return, and there's suddenly got a white space where you can make comments and say, well, we are paying the ACT because we believe we have to pay it under the legislation, but our calculations show it's excessive. Now, in that case, HMRC, in the knowledge that we now have from the second preference, would have said that you're quite right, you can have your ACT back. It really is as straightforward as that. But the shareholders will still get their credit. No one possibly denied them their credit. It can't make any difference when you fill in a return whether you bring in the correct amount of foreign tax as a credit anticipating what the CJEU was going to say, but then paying the ACT because that's what the domestic rules say. It won't make any difference whether you do that or whether your mistake is at an earlier stage of thought, and you simply think, well, I can't take any credit for the overseas tax, so I'm going to pay the ACT. It's exactly the same thing. So what is normatively defective is the payment of the ACT. As I said right at the beginning, the payment of the credit to the shareholder is not a consequence of the payment of the ACT. The payment to the shareholders is shareholders entitled to it.
As I understand the revenues argument, if I reduce it to its simplest formulation, it is that you're effectively seeking double recovery, in that you're seeking to get back the ACT which should not have been paid if adequate tax credits had been given. And you're also receiving now the tax credits which ought to have been given and which can be used to reduce tax liabilities in the way in which they ought to have been used, as it were, donkey's years ago. And the argument is you can't, as it were, recover both, at any rate on the basis of unjust enrichment.
But that's the argument. It's just plainly wrong, because we're not, in no way, HMRC disenrich themselves by paying the shareholder credit. They don't disenrich themselves. They're obliged to pay that by Section 241, Section 231. It's nothing to do with the failure of our system to. It's nothing to do with the failure to pay ACT. The shareholders get their credit because franked investment income has exceeded. Shareholders get their credit because they get their credit under Section 231. And whether ACT is due or isn't due is entirely down to the operation of Section 241, which compares the amount of credit received in franked investment income and the frank payment. So we're not seeking a double recovery at all. If you ask what is normatively defective, what's normatively defective is the payment of the ACT. So the revenue haven't been disenriched by paying something which they would, if everyone had got things right in the first place, ACT would never have been paid. The foreign tax credit would have come through, would have fed through Section 231 and Section 241, and the shareholder would have got their credit. If everyone had got it right, ACT wouldn't have been paid, and the shareholder would have got the credit. Now, what they got wrong was paying the ACT on top of the credit, which they didn't know they were entitled to have. And it really is a very, very short point.
But the argument against you would be that the tax credits could only be used once, and you are able to use them now. So you can't use them now to save tax, the argument would run, and at the same time recover the tax which would have been saved many years ago if you'd received them at the proper time.
I find that a very puzzling argument with respect, Mark. I mean, if we go back to basics, and we fill in the tax return correctly, no ACT would have been paid, assuming the amount of foreign credit is exactly equal.
But the tax credits would have been used up.
Well, they would have been used up doing exactly what they're meant to do, which is to feed to the shareholder.
whereas you now have them unexhausted.
No, we don't. They've been used, the tax credits have funded the shareholder credit. They've been used up. ACT was wrongly paid. ACT has nothing to do with it. ACT was incorrectly charged.
Yeah.
The tax.
Well,
the tax credits come through. It doesn't matter how deep the roots and how high the branches. These were other issues before the CJEU at the second reference, where the revenue was saying, oh, it makes such a difference if you've got deep roots, it's coming through, or you pay ACT at a higher level. The CJEU said, no, all irrelevant. The question is, has foreign tax been paid? Have you given a credit for that foreign tax as you would have done for UK tax? The answer is no. Now, that credit is to be used in accordance with sections 231 and 241. It doesn't matter when they're used, but they're used in accordance with that. So I don't, with respect, understand your lordship saying they're used only once. They're used in the way they had to be used.
Yeah.
And
I don't want to take up more time with it,
Yeah.
Mr. But I just thought it would be a good idea to put to you squarely what I understand to be the revenues are.
well, if that is the revenues argument, as I say, I just can't understand it. Because I come back to my very simple example. Let's assume that in filling out the return, someone makes a mistake, and they instead of saying the amount of ACT paid to the revenue, forget about foreign tax, just a domestic thing. The amount of ACT paid to the revenue, instead of being 50,000, they write 150,000. Someone just typed a 1 for, and they pay 150,000, and it should have been 50,000, and the credit that goes to the shareholder is 50,000 because that's the correct amount. And then someone, finance director, looks at the accounts afterwards and says, "What on earth have you done here?" And you write to the revenue and say, "We paid this by mistake." So you get your ACT back, you get the excess back. It doesn't affect the shareholder credits at all. Shareholder credits are to be taken. Shareholder credits are to be given as part of our imputation system. You are imputing the company profit to the shareholder. That's exactly what it is. All that ECJ1 says is that you have to take account of the overseas company profits when you impute to the shareholder. And what ECJ2 says is, and when you're doing that, the amount of credit for the overseas tax isn't the actual amount of tax, but it could be increased to the nominal rate of tax. And you impute that over to the shareholder. And that's what Advocate General Phil Hood was saying. That's what the whole imputation system is designed to do. So I don't know if I've squarely addressed what I don't understand to be my learned friend's argument, if I can put it that way, but I've done my best.
I think Lord James has a question.
This is, I hope, a rather simpler and more basic question. I think you said twice in response to my lord's questions, the amount of ACT actually paid by the UK resident parent company is irrelevant to the amount of the tax credit which the shareholders of that company receive. And I just want to check that I'm right in understanding why you say that. If we look at section 2311 on page 3078, I'm sure you know it by heart, Mr. Aronson.
No, I'm hopeless at numbers. You're not just know me well enough. No.
I'm still learning.
Yeah.
And this operates not merely, as I understand it, between the parent company and its UK subsidiary, but between the parent company looking upwards and a shareholder who is a person resident in the United Kingdom.
Yes.
And it gives the shareholder the credit not by reference to what's actually been paid by ACT, by the parent company, but by reference to the ACT rate in force at the time. And that will catch in a case where the parent company's franked payments don't exceed its FII, the ACT paid by the subsidiary. Therefore, if you attribute by reference to the conforming interpretation of Section 231, you effectively cross out resident in the United Kingdom, you get a situation where the foreign subsidiary is treated as if it had paid ACT. That then may mean, and you claim does mean in most of your cases when you do the detailed accounting, that parent co doesn't or shouldn't have had to pay ACT. But nonetheless, the individual resident in the United Kingdom still gets the tax credit.
Yes.
Not by reference to any conforming interpretation, but just by reference to the literal words of Section 2311.
Well,
because he gets it by reference to the ACT rate in force. Not by reference to the fact that somewhere down the line somebody's actually paid ACT.
yes. Yeah. My learned friend would probably say that you have to read that in conjunction with 241 because ACT
Yes.
and the tax credits go together. And
Yeah.
I mean, 231 is there and 241 is there and 238 are there. But I think what your lordship has said is probably technically right. But the
I'm relieved to hear it.
well, it may be technically right. I'm not going to say probably technically right. It may be technically right, but with respect, it doesn't really matter. The key point is the tax credit is given by 231. And
Yeah.
ACT, the amount of ACT that has to be paid is determined by 241.
But yes, I mean,
That's the key.
My question is simply to make sure I'm right in thinking that 231 operates not merely between the UK parent and its UK subsidiary, and now in a conforming way its foreign subsidiary as well, but between the UK parent and its own shareholders.
Yes.
So as to
yes.
define what the tax credit is that the shareholders get.
Oh yes. Oh yes.
Yeah.
Yes.
Yeah. Thank you.
Yeah. And 241 deals with how much ACT has to be paid, which may be
Yes.
nothing.
Yes. No, I understand that.
It may be loads.
Yes.
It may be the full amount on the dividend if there's no franked investment income. It could be half. It could be full.
But the purpose of my question is just to be sure that when the shareholder does his tax return, he doesn't have to produce a certificate telling the taxman what his company, his parent company, is actually paid in ACT.
Not at all.
He just says, I've got a dividend from a UK company. This is the ACT rate in force. This is the amount of my tax credit.
That's right.
Yeah.
But this may have enabled me to shorten matters. Might just take a second to see where I've got to. I should look at the second reference, which is in Appendix 1B, the tab 25. And that's at, yes, that's at 1640.
Before you go further, can I just make sure that I've not been barking up completely the wrong tree? I haven't understood this case to be concerned with individual shareholders. I thought that the recipient of the person entitled to the tax credit that we're interested in I thought was the parent company.
But only in respect of the calculation of the amount of ACT that was correctly due.
Yeah, yeah.
But now the HMRC at this rather late stage have formulated this proposition. But actually, you win on all your points about the ACT, but you don't get any money from us because we paid a tax credit out to the shareholders. It's only because they've raised this argument, otherwise we wouldn't be bothered with this. But we're saying, well, that has nothing to do with the fact we're entitled to our ACT back. As my Lord Briggs has said, the shareholder gets his credit because that's the way 231 operates, and the amount of ACT payables is the way 241 operates.
Yeah, but-
So it's not that your lordship's been barking up the wrong tree, you just haven't gone high enough up the tree, if I can put it that way.
But you're not seeking to recover the ACT on the basis of a statutory entitlement. You're basing your claim on the common law of what in recent years has been called unjust enrichment. And the argument against you is that in considering considering the extent to which the revenue was enriched, it's necessary to take into account the liability which it also incurred.
But the revenue haven't been in any way disenriched, if I can use that expression, by paying the tax credit. They've got to pay the tax credit because that's the shareholder is entitled to it. We receive our ACT back simply because the CT 61 computation was incorrect in that we didn't take into account the foreign tax credit. So the revenue have not been disenriched. They've not paid anything as a result of our not paying the ACT. When they pay us the ACT back to us, they don't say, well, or rather, when we pay the ACT to them, they didn't say, well, we spent that money immediately on giving a tax credit. It had nothing to, the tax credit was not to do with the ACT. Tax credit was due because of the underlying credit for the overseas tax. So they've not been disenriched, carrying out the normal obligation to give a shareholder a credit.
I see.
I think when I said your lordship didn't go high enough up, there actually isn't a tree to climb up. It's a very straightforward proposition. If, as my learned friend strove so hard to make out yesterday, the tax credit depended on the payment of ACT, so that if ACT was wrongly paid, the tax credit shouldn't be paid, then my learned friend would win. But that's just the false premise. And when I see the time, I could use the short adjournment to see to what extent I can now cut back on what I was going to say. I've got to deal with the treaty credits, which I think I'll be able to deal with quite briefly.
Very well.
I will endeavour to finish by 3 o'clock to let my learned friend get cracking on the fascinating Sempra stuff.
Thank you very much, Mr. Aronson. We'll adjourn now and resume at 2 o'clock.
Obligement.